So, good evening, everyone. Today we'll be discussing about check bounce matters, how to handle clients who have been cheated on their money, which they have made payment to some other person, and how we should ensure that we should get them justice through court, and what are the court procedures to be followed. We'll be discussing in this seminar, and I'll be discussing uh, one of our own office case where we got a court order for arrest warrant where a person defaulted on paying 2.5 lakhs. We'll discuss what all steps was involved during the court procedure when we filed the case. So before starting that, I just want one or two students, like, what is your understanding about the process to be followed when a person bounces check, which is money has to be paid to somebody, and he presents the check. What is your understanding? Can one of the student just tell me about your understanding?
Okay. To my understanding, usually check is presented as a security, as a collateral for
Mhm.
taking any loan. If
Mhm.
in case the person who has taken a loan fails to repay the amount, the person for whom the check has been present, he can file a case in a court
Mhm.
stating that this person has not repaid my amount. So for that reason, it can just take a legal action for non-payment of the non-payment.
You're partially correct, but we should not use the word loan. Why? Because a person who gives a loan should have a license to give loan. He should have obtained a license from regulatory authorities to give loan. Then only he can give loan. So here we'll be using the word funds. Suppose you give your friend 1 lakh rupees, but you're not giving it as a loan, you're only giving it as a fund. So in that scenario, he will give you one check for rupees 1 lakh. So here only transaction between you is, it is just a promissory note that that person who has received 1 lakh from you should repay it through the check he has given it to you. I have one question for you. Lakshmi Priya, can you collect interest on the money you have given to your friend?
Uh, as per your recent discussion, if it is licensed person, yes, you can, but
Mm,
officially he cannot. But
mm.
on mutual understanding, he can take a interest.
Yes. Yes, most of the times many clients come that they would have entered into some understanding with their friends, given some money to their friends. Yes, but if that money has been transferred above 50,000, if it has been transferred, then such money can be transferred online or through any instrument and transferred to their bank accounts. Then such money we can legally claim back. But we cannot add additional money to the, suppose some person gives you a blank check and you fill some additional money. If you fill some, you have paid 1 lakh and you are filling 2.5 lakhs. So tomorrow again you have to prove before the court this 1.5 lakh, how did you pay him? And if you say that you paid by cash, court may not accept it. So always you need to show the proof that you have paid only through a online check transfer, bank transfer, NEFT, etc. So that transaction should always be available. Cash transaction, as everybody knows, has a limit. It is only up till 50,000. Above 50,000, so all such cash transactions should be always through an accountable way, check or etc. online. So now let's start. What is section? Before that, let me discuss about ingredients of section 138, like when a check is bounced, what all the measures you need to take while filing a private complaint. So check bounce matters are basically filed to punish the person who has defaulted on making payment, and the bank gives several reasons. So five ingredients to file private complaint before a magistrate court. So the first ingredient, check must have been drawn for discharge or existing debt or liability. So here we will not use the word loan. So can be called it as debt. So every check has a validity from the date you enter. Suppose some of your friends or some of your has given a check with a date. So within after that date, the check is valid only for the next 3 months from that date, and after 3 months, the check is barred by law to be presented before bank. So any check you receive as a guarantee from your friend or any of an unknown person, that is valid only for 3 months. So once you present this check before the bank, that the check must be returned back with necessary reasons. With the bank insufficient funds, signature may not tally, the account may be closed, the money may be stopped by the banker, payment may be stopped by the banker. I will also show you all the different reasons what all bank can give. And immediately after the dishonor of check from the information knowledge the person obtains, he has to inform the drawer by through a notice within 30 days from the date of bounce of the check. So within 30 days he has to inform. So once the notice reaches the once the notice reaches that person, from that date, you after exhaustion of 15 more days, you can go and file a private complaint. So you have to follow this steps. So initially you present the check should get dishonored, and within 30 days you have to send a notice. Once the notice is served to that person, and within 15 days, if he does not come forward to clear your amount, then you have to go before and file a private complaint. So you always have to follow these timelines. So this is what the ingredients of section 138. So I'll make it in simpler language. So any check is valid for 3 months. Point number one. So within 3 months, you have to present the check. After presenting the check should get dishonored. After dishonor, you have to immediately send a notice asking it to pay or ensure that sufficient funds are maintained to withdraw the check balance. You have to send him a legal notice or a simple notice. So within 1 month, you have to send a notice from the date of dishonor. So after that, again, from the date of receipt of notice by the opposite party, after a lapse of 15 days, you should go and file a private complaint. So I have one question. What will be the validity of a expired check? What can such person do? Can anybody answer this question? If check's validity is expired, does he have a legal remedy? So, yeah, yes, Arjun.
Yeah, means if we can give any medical reason that if a person is not keeping well or he was out of station or out of country or something like that, that can be an exception. Or
No, sir. Just a minute.
It's also a person's responsibility who receives of that check with the date, or whether it is at par check, or uh, whether what is the cash limit. Say for instance, he has given a debt of 5 lakh and the check limit is only 2 lakhs. so which is like he cannot recover. So it is a responsible of a person who gives the debt to ensure the valid check as well as the at par checks and limitation of the check.
Sorry, Jagdish, please come again.
Sir, I feel it's from my point of view, it's a person responsibility who gives the debt, right? So who has to ensure he has to ensure the validity of the check, whether the check, the limitation of that the check. I mean to say, the value of that check. If the value of check is say he has given a debt of 5 lakh and the check value the check value he can claim only 2 lakhs, so that where the debt who the person who gives the debt, he is responsible to ensure to have this valid checks before issuing the debt.
The person receiving the check for the debt he has given to the opposite person, he is liable to ensure that he gets the check on correct date, and date should be proper, and also he should ensure that correct amount. And one more thing, if the check is barred by 3 months, in such a situation, he may not have a remedy, but he can file a civil suit and claim the money. But when he files a civil suit, he will exhaust the option of punishment in this check bounce matters, because private complaint is basically for a criminal punishment for dishonoring the promise he made through the check. So in that situation, he may file for a civil suit for recovery of the money, and he may have to pay additional stamp duty of 6% or as decided by the court, and he has to claim the money back paying the court fees as a civil suit. But it cannot be again treated as a private complaint if that limitation is barred 3 months. I hope everybody understood. Yeah.
So, can you give one simple example for this?
See, Lakshmi, I took one loan, 1 lakh from you, and you give me a check of 1 lakh. And today is the date, and I have given you 1 lakh, and you present it on the fourth month. So bank will return back the check saying that the timelines are barred. Time is barred. And after that, you cannot file a private complaint because the check is barred by limitation for 3 months. You may have to file a civil case for recovery. But if you file a private complaint, you file it for punishment, arrest, and put him in prison. But in civil case, you file a Mr. Ajay, I'm recording this. It will be put on YouTube. Yeah. So I will file a civil case. I will file a civil case, but here I cannot seek for punishment or put him in prison. But here I will seek for recovery of that money. I will attach any of his properties for recovery of that money in a civil case.
Got it, sir.
Okay. So what are the different types of refusal made by banks? Insufficient funds, signature is not tallied, account is blocked by the bank, or payments are stopped. We will just look into some of the reasons here. So there are bank can issue reasons. There are many reasons. Funds insufficient, exceeds arrangement, signature may not tally, stop payment, payment has been stopped by that bank person who has taken that debt. Instrument, it may be post dated, or instrument mutilated, or it may be torn. Account closed, reason for return, crossing, and RBI government or court orders. So all these reasons are listed out here for what all reasons the bank can refuse to honor the check. So we just already discussed this, the ingredients. So you need to understand you have a timeline of 45 days. Once from the date of 30 days, once the check gets dishonored, you have to send a legal notice within 30 days. So once he receives the notice, from that date of receipt of notice by the opposite party, how will you get to know that he has received? If you are sending it by registered post, you will get the acknowledgement online. You can check that he has received that online. You can take a printout. With that proof, within 15 days, you can go and file a private complaint before magistrate. So we'll be discussing now. I'll be showcasing you the documents what we filed for one case till the court decree, what all orders they give. I'll be showcasing you. So here, just briefing you of the facts. One person wanted it to enter a house for a lease purpose for an amount of 16 lakhs. In the initially, he paid 6 lakhs. After receiving 6 lakhs, that house owner gave the house to some other person for lease purpose. So, but during the he has taken his 6 lakhs back. In this 6 lakhs, he returned 3 lakhs, 3.5 lakhs, and he gave two checks for 75,000 and one check for 1 lakh, almost 2.5 lakhs. When he presented before the bank gave a notice. There is insufficient funds in his account, and so whenever he contacted, he was not available, and he did not refund the money back. So once the check got bounced, we have sent him a legal notice on this 13/5/2022 within the timelines. So here I'm just showing a marked legal notice where we have sent him a legal notice. So we have stated all the facts about him receiving 6 lakhs and refunding 3.5 lakhs, and also he also cheating him by giving the house to some other third party instead of my client. And then when we have presented the checks given by him for 2.5 lakhs, the checks have got bounced, stating insufficient funds. So all the check numbers have been mentioned and all the details have been mentioned. So he has again delayed for so many times. So here both the checks came to be returned with a banker's note, funds insufficient. And again, as per your instruction, my client, he presented 2-3 times to recover that money, but both the times whenever he presented, the bank refused to honor the check, stating there was insufficient funds. So we have sent him a notice and asked him to return all these things, and we have taken action by filing a private complaint in the court. So now let's look into the private complaint. So we have presented the proof of the online receipt what we have sent him through registered post, the acknowledgement received by him, signed by him. So this is the draft of private complaint. So here it will be PCR number in Bangalore if you file, criminal case number in 2022. Between is the complainant and is that accused. Here we'll use the term as accused. So memorandum of private complaint under section 200 of CPC, but this 200, I think now it is Bharatiya BSSA. I'm not aware about the abbreviation, but this 200 section will not be available. So some other Bharatiya Nyaya Samhita, just like that for CRPC Bharatiya, there is one more this thing. So sections will be different. We have to file under that section along with read with section 138 of Negotiable Instrument Act 1881. So this is the first page of the draft. Second page also we have stated the facts. We have where all we have produced, what all the statements the banks have given. We have showcased all across. And we have also produced, and in the end we have to look for the prayer. What is the prayer we ask in this private complaint? Here we cannot ask for recovery, but we have to ask for punishment under section act and direct the accused for we ask for payment of failing which the accused may be sentenced to imprisonment, impose cost, charges, expenses and penalty on the accused, and punish the accused in accordance with law and with law in the interest of justice and equity. Here we in the prayer we have to ask for direction for payment and also for imprisonment. So, and after once our private complaint is accepted, the notices, the court will order notices to the opposite party. And after the here, the accused did not appear before the court, so we got an ex parte order in his absence. So we have done evidence of producing all the documents. So we have produced the original checks to the court. We have produced the shera or the note given by the bank for stating insufficient funds. We have to produce all the original documents. Here we have mentioned Xerox copy. Only during filing we produce Xerox copy, but when it comes for the stage of evidence marking of documents, we have to give all original documents. So this is all in Kannada, where we have produced all the original documents. The court has marked all these documents produced by our side, by my client. So the court has taken note of the insufficient funds and the dishonor of check. So, and it has taken, generally the person has to get into the box, he has to state the facts, and that those facts will get dictated. Generally, affidavits are not allowed. So in such matters, the judge takes the statement given by that person on which all dates he has produced, and the court has taken note of the same. So all the checks issued by him. So these
Hello,
are
Abhilash. Good evening.
yeah. These are the notes issued by the bank that stating that funds are insufficient. So this has been marked before the court during evidence time. So all the three checks, the insufficient funds issued by the note issued by the banks have been presented before court. The court has marked these documents. We have also presented one affidavit. So now let's look into the final verdict. What is the judgment? There is a private complaint filed by complainant against accused for the offense punishable under section 138 of NI Act. So the judge has dictated the brief facts. So about entering into lease agreement, and there was an agreement for payment of 16 lakhs, for which we paid 6 lakhs, and 3.5 lakhs was refunded, 2.5 lakhs, 3 checks was issued. All these details have been dictated by the judge in his judgment. So in final heard arguments of complainant, argument of accused side was taken as nil because accused did not contest this case. I have carefully perused the materials placed on record. The following points that would arise for my consideration: whether the complainant establishes the accused has committed an offense under section 138. For this point number one, it is specific case of complainant. So judge has uh, taken hence complainant praise for conviction of the accused. Prosecution witness number one has reiterated the arguments made by complaint in this examination in chief filed by way of affidavit. So the accused person has not come forward to contest the case. So his cross examination has not happened in this case. So all these details has been marked exhibits, original documents, original checks, original bank note for insufficient funds has been produced before the court, and these have been marked as exhibits. So finally, considering the absence of the accused and non-execution of the NBW issue, the recording of the statement under section dispense with this direction issued by Honorable Court. So here one or two judgments have been produced by our office. So finally, the order issued by the judge. Acting under section 255 of CRPC, the accused are convicted for offense punishable under 138 of NI Act. Accused is sentenced to pay fine of rupees 2,60,000 only within 1 month from the date of this order. In default, accused shall undergo simple imprisonment for a period of 6 months. Out of the fine amount collected, 250 rupees, 2,50,000 shall be awarded under section 357 of CRPC to the complainant as compensation. After completion of appeal period is over, then remaining amount of rupees shall be deposited as fine to the state. Bail bond of the accused will stand cancelled after completion of 6 months. So this is how we took the closure of the case from start of filing private complaint till obtaining a court order. So in this matter, once the court issues this order, the local police station will pursue that debt defaulter. They will go behind him, asking him to come and make the payment before the judge. If he does not, then he will be put behind bars. So sometimes the judge may allow him to pay in installment twice. He may pay in 3 or 4 installment twice. Such installment option may be allowed. So I am open for any questions from the audience. Is anybody having any doubts?
Yes, sir. Actually, if the person who has given the check, if he dies in that scenarios, what will happen?
See, legal heirs can be made a party because legal heirs are liable. So, suppose father had to pay the debt, but he died and his son, as a legal heir, it's his liability to repay all the father's debt.
Okay, sir.
But in such scenarios, the PCR may not become applicable, but it may he may have to attach their properties. Because the check was not defaulted through his account, but still liability exists.
Okay, sir.
So one question, in
Yes.
case I am the person who has given a check, but I've shifted my home, or I'm out of the place where my address is.
Ah.
But whoever stays in that place might be not my family, some neighbors or someone. They are collecting the this one notices, whatever the court is producing. But unfortunately, it has not reached the person who has presented the check. So how can you consider that he has received the notice?
See, sometimes what happens is the court will give an order. Tomorrow at a later date, you are the victim and you find his address. And case can be restarted at that point of time, asking the police to arrest such person. Because the court may give during the serving of notice, the person may not be there. You may take newspaper publication. You will publish that if so and so person, if he does not come and clear the debt he has taken, uh, the court may arrest him in future date. If notice cannot be served on his address, if he is not found in address, you will take a newspaper notification. Thereafter, filing that newspaper notification, you will the court may give an ex parte order in his absence, and thereafter the tomorrow at a later date you may find his address. Tomorrow the same order can be opened again, and you may have to enforce that order.
Noted, sir.
Okay.
So one question, sir.
Yes, yes.
It's Rishabh.
Uh,
Sir, if a stipulated time we have not we are failed to file a case, then what is the
uh.
issue? So what is the time limit? What we extra time we will get it?
Sir, the check timeline is 3 months from the date. Suppose
No, once
that
a check is no check that time he has not mentioned the date. He has given a blank check without mentioning the date. So we have mentioned the check date and we have kept it. We have already the check has got bounced back. Okay, sir. So once after that, then he's saying I'll be paid. I'll be. He's just waiting for one after 45 days or something. You stipulated time. What he has told me, sir. Then after that time also over. Then what is the time limit? Any time limit will be there or how it is?
So here you should be aware the check is valid for 3 months. So on the first day, on the first month you produce the check, it gets bounced, and he asks for 2 more months time, and you wait till the 90th day, or the from the so 1st of April, April, May, June.
Yes, yes.
July 1st. So July 1st, on the 1st of July, you have to compulsorily send him a legal notice asking him to come and pay forward. Once he receives the notice,
No, sir. My question is like, see, sir. My question is, sir. My question is, sir. See, April month he has given a date. We are deposited on April month only. The check. So the check date is there valid up to July.
July
July, right,
1st.
sir. So even the after the check bounce, that time it calculated or the 3 months from the date.
See, you can present multiple times the check in this 3 months. Okay, sir.
Okay, one. So my doubt is why after check bounce again the same check I cannot deposit, no, sir.
Yes, sir, you can deposit. The bank will return the check back.
Yeah, banks once returned back check, then
Ah.
again they will refuse to check depositing, no, sir.
No, 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 no. Bank, they will give you back the check, and the
Acha, okay.
drawer may ask you to present the same check again to the bank. Bank will not cancel that check or
Acha,
tear the
okay.
check. They will
Okay.
give that check back to you with a note stating insufficient funds.
Yeah, exactly.
You can
But
present
the
the check
same
again
check I
within
can
3 months.
deposit that we do say.
Yes, you can present the check again. Same check.
Okay. If the date is exist. Yes, exactly.
Yes. 3 months you can present multiple
Okay, what is it?
times. Unless and until it gets honored, you can
Acha,
present
okay.
multiple times.
Sir, I
Okay, there
have a
is not
question.
limit or anything kind of.
There is no limit. The bank will be deducting some charges as fine against dishonoring of check and wasting bank's time.
Sir, I have a
What
question.
what
I have a
what
question.
is the
Sir, see, suppose this basically this negotiable check case, if you given any money as a cash, so we don't have any evidence in that case. So in that case, only whatever we do online transaction or phone pay, only this will be considered as a evidence. Cash will not be whatever we given as a hand to hand cash that will not be considered.
See, sir, I one of my friend, uh, he he gave a blank check.
Okay.
Okay, that person wrote 40 lakhs on
Okay.
that check, and this
Okay.
person was not bound to give a single rupee.
Okay.
Because of some they confused this friend of mine. He signed the check without putting a date, without mentioning any amount or figures. He gave a blank check. That person wrote 40 lakhs in the check
Okay.
tomorrow, and that person is claiming, I have a video record of giving you some money. Even that proof will not be accepted. So first of all, any transaction above 50,000 has to be made through instruments like check, NEFT, online transfer, RTGS. Only this way above 50,000 you have to compulsorily make. Otherwise, the court will ask you what is the source you got that money, and it will also question you uh, that as per our money transfer law, you cannot transfer anything above 50,000 above 50,000 as cash. You should always do it only as online transfer. So even if that person claims that I have given you 40 lakhs, he will have to give proof that two things he needs to prove: where did that money come to him from, and whether he has given his case will withstand only if this person giving the check accepts the fact that I received the amount through cash before court during evidence. If he does not accept, if he denies, then his case will not withstand.
So, sir, East Ham, in East Ham, if we make any agreement, we would have given 40 lakhs to him, and such evidence also it will not
It's
work out.
illegal, sir.
Illegal, huh? Okay.
Illegal. Online transfer compulsory.
Okay.
Or otherwise, that person whom he has received the money, he has to, during evidence, he has to come and accept I received through cash. Then only your case will have a chance. If he
Okay.
fails to accept, no, I did not receive any 40 lakhs. He asked me to sign this agreement. I signed it, but he did not prove me. But now he has filed an illegal case against me. Then your case is a weak case.
Okay.
So
Sir,
what is
again, see,
Because the court is only looking into facts. Whether have you paid him 40 lakhs, though he may have signed, what is the proof you have paid 40 lakhs? There is no proof. You may create witnesses, but witnesses, even everybody is at wrong by doing illegal transaction by cash. Cash transaction above 50,000 is illegal.
okay. Sir, second scenario. Sir, suppose if I given like actually I don't deal any business with you actually, but like I given check to my friend. So my friend that check like I have not written his name actually, but name it was blank. So like he had written your name and he given check to you. In that case, so how do I prove sir?
So you have given check to me and you have not paid me back. So sorry, I will have to prove before the court that I received money from you. You
Yeah,
have given the check to your friend, and your friend has given the check to me. Now I
yeah.
will have to file a case against you, but the burden of proving that I received money, it's upon me. I have to prove how I received money.
Okay, but without proof and no, like I don't do any business with you, so it will not work out actually.
Yes, sir.
Okay. So again, third scenario. So basically, so I would have gone for some personal loan or housing loan. In that case, they would have collected five checks, like the blank checks. In that case, how they will take it, sir? In case if I'm not able to pay house loan or personal loan.
See, there is several procedures. They will send some notices under several sections. I'm not aware about those sections for recovery of that, and they will present those checks, and those checks will get dishonored. Whatever checks you have given for the banks, and they will again forward those case to debt recovery tribunal. So in the DRT, debt recovery tribunal, whatever property, the original documents you have mortgaged, and they will come and first take possession of that properties. They will send notices to vacate that house and everything. They will come and take possession of that by sending a notice. If you are reluctant to leave that house, they'll get a court order with police protection. They will empty the house, take possession. Thereafter, again, with whatever interest it is due, they will advertise such properties for any possible buyer, and they will recover the dues that way.
Okay, sir. Thank you.
Okay.
Sir, in your case, how long did it take to the complete timeline? How long did it take to get the order, sir?
I'll just tell you the order date. So the order date is on that. Decided on 1/6/2024. I think registered on 26/2022. Almost 1.5 years, sir. 2 years.
2 years. Okay. Okay.
1 year, 11 months, 3 days duration to get this order.
Okay. So if the case is complicated, it may take some more time.
See, sometimes, yeah, sometimes the opposite side may keep buying dates for some
Okay.
reason. I'm not well. Somebody is sick at home. Like well, that was like there will be thousands of cases pending before each court. Every day there will be a hearing of almost 150 to 200 cases for different stages. In court, if you have visited any court, you will know that first they will call the roll call for service of notices, whether the notice has been served, and they will take the case to next stage, and they'll give a date for each case, and then they will call for petitioner evidences, cross examinations. So those who are present, they will keep the file aside to do their evidence inside the box. Thereafter, they will again call, in the first roll call, they will again call the cases for arguments. Those who are present and say that I will argue, their file will be kept aside. So once that first roll call of cases are called in the first half an hour, when at 11 a.m. generally 10:30 11 a.m. the court starts. After that roll call is start, the court initially starts with for taking petitioner's evidence or respondent's evidence. Thereafter the court may start taking cross-examination of these people who are giving affidavits or evidences. Thereafter, arguments of the case, those cases which are pending for arguments. This is how a procedure in the court takes up.
Okay.
Okay, sir.
Yeah. Thanks, sir.
Sir, in court, basically to postpone the proceedings to, like, if the accused if is not present, to postpone the case, how much fees for each postpone, how much we need to pay as a fine, something in the court?
You don't need to pay, sir.
So
Who
we
told
can
you?
just postpone.
See what happens. You are asking, but your understanding is not correct. Here, I understood what you are trying to say. Suppose accused is not present on a particular date, the court may give 1 to 3 chances if he has a valid reason.
Okay.
And further, if he delays, suppose accused has to come and file written objections.
Okay.
So on that written objections, he does not come. Accused will not come and file his reply on the complaint. So that reply, the stage of filing reply will be closed by that court, and the court will move the case to next stage for the complainant's evidence stage. So the accused loses the chance to file a reply to that case. His case is a weak case. Now, to reopen that stage for him to file reply, the court may impose him a penalty, a cost of 500 rupees or 1000 rupees. He has to pay that cost to that advocate who attended, for the complainant's advocate who attended the case for several days. He has to pay that 500,000 rupees cost. After paying that cost, the court will allow the accused to file his reply.
Okay.
Okay, sir.
Yeah, sir.
For all this time that's being spent, will we get monetary compensation for the inflation thing?
See, sir, here the court does not look whether in check bounce matters. Here it is an understanding that somebody has taken some money from you and he has given you a check. So there is you did not enter into an agreement that in the matter, if you fail to pay this money in this time, you are supposed to compensate me for any losses. But here, if you want to see profit, then you need to have a license to have interest on such money you have paid to such person. This is how court will look into whatever. So you have given it on a trust so that he will return it back, and he has not returned it back. So this is how the check bounce matters are looked upon. So it is not a profit making business for anybody who has given loan to somebody. You have given it out of your own knowledge, out of your own acceptance that in the event, even if he delays, I will be only responsible to receive the amount what I have paid. Here in this case, 10,000 has been awarded extra. That is for court for running this proceedings, all these things. So in a matter, it is like a loss-making case only. Check bounce matters most of the time. Here you have to pay advocate fees for per hearing. You will be paying again for filing private complaint. You will be filing again. So it is a risk you are taking when you are giving the check in the matter if it bounces.
So if you are not a loan shark, if you don't have the license, then you are not allowed to make an agreement that says, in case if you fail to, honor
And
this.
such agreements are illegal unless you you make a profit. Unless you have a license, such agreements cannot be held valid.
Okay.
So if you get a agreement, if you get a license only, you are a loan shark. As straightforward as that.
Yeah.
Hmm.
Got it. I mean, if you are giving out of goodwill, then there is no option for you to make out for the loss
See,
that
you can file a case, then you will have to file a separate case for damages. For contesting this case for 2 years, you have to file a civil suit asking the court to award damages for you.
Okay. In that case, however long it may take to get the judgment, we can hopefully hope to get compensated for that, right?
See, yes, civil suit you can file. The court may not give you the amount you are expecting. You may claim 50,000, 1 lakh. Again, you will be whatever amount you are claiming, you will be paying 5 to 6% as duty as case fees for the court to register that case, and then that case will be allowed. And that's totally upon discretion of the court how much compensation you should be paid. So once the PCR gets decided, then again, if you want to file a case, then again that case may run for 1 or 2 years.
Got it. Thanks.
Okay.
Sir, in your case, the order was pretty much clear. So even after that order, can the accused go to the higher courts and appeal?
See, if he has to go and appeal, he has to pay some money, he has to deposit some money, and he has to go and appeal. I think 50% he has to deposit in 50 or 75% he has to deposit before magistrate court, then he has to go and appeal. But he should appeal on reasonable grounds. But whether a transaction happened or never happened, he has to prove that's his burden.
Okay. Yeah.
Any other questions?
So regarding sale deed, so example, I have sold a property for 10 lakh rupees. Then I have received two checks. One is 5 lakhs and one is another 5 lakhs. So the 5 lakh, one check got honored and one more got dishonored. So what is the process? What can I do for this?
Go to go to sub-registrar, first file a complaint that check was dishonored, stop the reverse the registration. You can file one complaint, and also you can stop that this thing. So if the check is dishonored, and also get a direction from civil court to reverse the transaction, to reverse the sale deed.
So this I should go to sub-register or court, sir?
So both you need to go. Sub-registrar file a complaint. I believe sub-registrar may not reverse that, but get a court order immediately, an injunction asking the sub-registrar to reverse the this thing, ownership in your name.
Okay.
Generally, all this property transactions, mostly best way of doing is either by getting a demand draft ready or through bank transfer, RTGS. Check is a risky aspect unless you know the party.
Okay. Right, sir. Thank you, sir.
Any other questions? But again, in the check bounce matter, you have a right to file a check bounce case for recovery of that money. If you want to consider that sale is correct and you want that money, you have two options: either ask for cancellation of that sale deed, or you can go for recovery of that money by filing a check bounce case if you want that money.
Okay.
Sir, after filing the complaint with the sub-registrar, and once we approach the court to kind of reverse the transaction, will the
Cancel
court
the
be
sale.
kind of, will that be done immediately,
Yes, sir.
or will it take some time?
Yes, sir. Immediately you will get order under application under 39 rule 1 and 2. We file application to get an order for dishonoring of check. Immediately we'll get an order.
Okay, yeah.
So that order we need to give to sub-register, right, sir?
Yes. Yes.
Okay. So in EC also the transaction will be reversed.
Yes.
Okay.
Sir, in a check bounce case, if the accused is in a different state, how long court wait to send someone through SP office or so?
Generally, here first week court may send the arrest warrant to the local jurisdiction police. Sometimes the local jurisdiction police may take some money and write a note back to the court that person not found in address. Again, they send it pressurized through uh, commissioner's office. Again, commissioner will put pressure on local jurisdiction police. So, and also if you know that person, it's better you may have to go to that different state, and you have to ensure that local police people are working properly and taking action on that person, because this is a very difficult to recover, especially in the matters where person is residing in a different state. It totally depends upon the police people, how strictly they are working to recover that money.
Occasionally, like how after how many hearings the court will give direction to the other state police to serve the notice?
See, initially they will send, after the court order, they will send one notice for him to, that order has been given. If he does not comply within 1 month, so warrants can be, non-bailable warrants can be issued against him. The court will start sending non-bailable warrants against him. So after that, it will be sent to the first local jurisdiction police. Local jurisdiction police does not take speedier action, then it may be again sent to commissioner in charge for that place. Commissioner will again put pressure on their local jurisdiction police to arrest that person and bring him before the court. All these things has to be done. Generally, other state police will not involve their police people in bringing such person to the state.
Okay, sir. Thank you.
Sir, who will bear the expenditure of bringing that accused person to our state?
Sir, that complainant only has to bear that expenditure. And tomorrow, whatever expenditure is bearing, again he has to recover by filing a civil suit for damages.
Okay. Sometimes witnesses are called to the court by issuing summons. So many times they are made to wait from morning to evening. And in the evening they say the case is adjourned, come some other day. So even though he is become a witness in a good faith, so he is made to suffer because of his attendance, waiting there. So how it can be addressed, sir, this issue?
Sir, you know that our courts are burdened with too many cases. So generally, we advocates, we can only request the judge to take up the matter as early as possible. But what happens in our magistrate courts, every 3 months or 6 months, there's a transfers happening. Sometimes we would have done arguments and cross-examination, and judge may want again to do understand the case. He may again call the witness, or transfers happen. So this way, dates may get more extended.
Yeah,
Magistrate.
sometimes the witnesses are also given some fee. I have seen some people are getting some cost for attending the court cases as a witness fee. After if it is not addressed in one hearing or two hearings, is it legally admissible? Generally, in the court only the accused persons they will reimburse the cost.
See, you are telling about a situation. You may have observed it in this manner. What I understand is, so suppose the stage is for cross-examination of the witness.
Yes, correct.
So in that situation, the advocate does not want to cross. He wants to buy dates. The court may give him one date or two date, and above that, the opposite advocate, we will say that you pay the cost and you take time, because he has unnecessarily has come from a long distance, and you are wasting his time, court's time, everybody's time. You pay a cost of 500,000 rupees to that witness who has come here.
Yeah, I only got 2,000 rupees in one case as a witness fee, where cross-examination, second time they called for cross-examination, and the court made me to pay, court asked me, I got 2,000 rupees, sir, from that person.
From that person, correct, sir. Because your time you cannot waste when you are ready, and he has taken the liberty from the court to cross-examine you on the next day. You cannot again waste your time, but he
Yeah,
himself
but it
voluntarily
is,
has taken the date.
yeah,
He's
this is
wasting.
okay for a cross-examination, but for a beginner witness, they are not giving a cost. So,
See, it depends upon how your advocate asks. If your advocate asks for that opposite party to pay cost, they will pay cost. The judge will ask that person to pay cost. So if your advocate does not ask the opposite party to pay cost and he allows it, the court may give him a last chance.
Okay.
Okay.
Thanks.
Totally depends upon your advocate asking, or you yourself asking that I should be compensated for coming here again, and the advocate uh, taking adjournments several times and not doing cross examination and wasting my time. So
One more situation, can I just
yes,
but
please.
yeah, I am running one cooperative bank, sir. It's a society type in my taluka headquarters, and it is a licensed, and as you said, it is a registered a society, and we have given some loan to some of the people. They have not they have defaulted, so we have filed case against them in the court. So the court is not deciding since last 3-4 years. Still they are how we can get it addressed?
Sir, I cannot comment on this unless what are the stages your advocate has taken and what all stages has crossed during the course of your case. If the stages are completed, evidence is given, and the court, generally it is through debt recovery tribunal, and it will again they'll ask for the court first orders for taking possession of that property. Then you again call for auction of that property. If auction people do not come, and again whosoever is giving the best quotation to buy that property, you will accept and you will close that case. Generally, this is how banks work for recovery of money. So first is you send a notice that you send a notice to that person to vacate that premises and give the possession of that property. He will not vacate. You will go get a court order, and you will go for debt recovery tribunal. Through that court order, you will take possession of that property. After taking possession of that property, then the actual auction of that property starts, or you can call for highest bidders.
No, some urgency, because that money is not of any individual. It is all the shareholders' money. About 1,500 shareholders are there who have put their money in the bank. That money is operated through the society. So we are facing pressure from the shareholders. So effective case is not taken up for the recovery. So that is spreading to other prompt payers, like that. So really finding difficult to get it addressed and getting the relief from the court, sir.
You have to, the court process has to be followed.
Yes.
Here, as you know, that now we cannot do forceful eviction of people who are defaulted on rent. All those strict, you cannot harass the people who are not paid rents. So
Yes,
only
that
through
is
court orders you have to follow. Earlier, there were days when banks used to appoint recovery agents, and recovery agents used to harass and all this. Now it has become very strict, and criminal liability, criminal case can be filed against recovery agents who are harassing people day and night. So even that recovery agency type of work also cannot be done by banks nowadays. Whatever
yes.
has to be done only through court orders only. Through police protection, you have to take possession of that property. After taking possession, you have to go for auction. Line by line items, you have to finish it up.
Yes. Okay, sir. Thank you.
And most of the time, some banks will whatever the interest has been accrued within 3 or 4 years, it may become double that amount, and it has become very difficult to recover that amount. Whosoever is giving is the highest bidder for that property, you generally give it to that. Sometimes there are no bidders. In that time also, what the least amount, even some banks give it at a price which is a loss for them also. All instances.
Yes.
So any more questions? So I will end this seminar. So thank you, everyone. I hope everybody is in a position to advise a client if you meet somebody who is facing check bounce issues.
Yes, sir. Thank you. Very informative. Thank you very much.
Thank you.
Yeah, thank you, sir.
Thank you, sir. Bye.
Thank you.
Thank you, sir.
Thank you.